Good day everyone. My name is Abigail Sarah Kumar, matrix number 273092. We are from Group 1 and we will be presenting our first assignment on the topic of transfer of cases. The judiciary's priority is to practice without any biasness and discrimination towards the general public who approach the court with the faith that the court will maintain its high moral values and standards practiced among the judiciary in accordance with the legislation. So, in the context of criminal matters, the judiciary has the responsibility to provide equal opportunity and justice to the people in line with the Criminal Procedure Code. One of the many powers that the court possesses is the power to transfer cases. This is to ensure the judiciary's purpose is preserved and, as mentioned earlier, to provide justice and equal opportunity to people. So, what will we discuss in this short video? Well, we're going to look into two issues pertaining to this power, which is whether the consent of the public prosecutor is necessary when applying to transfer, and will the accused be exposed to greater punishment as a result of the transfer of case. After that, we will see some suggestions so as to provide a better alternative in overcoming these issues. And finally, we will see the importance of the power to transfer cases. When we look into transfer of cases, what does it actually mean? It means it is the transfer of a suit from one court to another court. The transfer may be made by magistrate or sessions court judge, the public prosecutor, high court, or with the accused's application. Now, the process of transferring cases are governed by the provisions in the Criminal Procedure Code. Namely, Section 177 is the magistrate's power to transfer cases. Section 417 is the High Court's power to transfer cases, whereas Section 177, 418A and 418B is the public prosecutor's power, and Section 417 gives the accused the opportunity. We will look into these provisions in depth later. However, despite this legislation, there seems to be a number of issues concerning this power.
Good day everyone, my name is Rekha Varugis, matrix number 272997. I will be presenting on the first issue that can be derived from the topic at hand, which is transfer of cases under the Criminal Procedure Code. The first issue is whether the consent of the public prosecutor is necessary in the transfer of cases from subordinate courts to superior courts. Section 177A of the CPC sheds light on the fact that the consent of the public prosecutor is vital in order to proceed to institute prosecution in the High Court. Subsequently, if the consent of the public prosecutor has been obtained to further institute prosecution in the High Court, the Magistrates' Court must first proceed to transmit the case to the High Court after the charge has been read to the accused, and this must cause him to be brought before the High Court. The High Court shall fix a date for his trial. When the accused appears or is brought before the High Court, it is important to note that in the circumstance that the public prosecutor has not consented and the accused is still brought before the Magistrates' Court, then the said court must explain the charge to the accused and the accused shall not be called to plead. A notable case in this instance is PP against Oladotun Lukmaru Umaru and others. This case revolves around drug trafficking. The accused was brought before the magistrate for the reading of the prosecution. Following that, the magistrate proceeded to transfer the case to the High Court. An argument was brought forth that the public prosecutor had not consented. It was then held that before the transmission of the case to the High Court took place, the public prosecutor is required to give consent first. A similar question arose in the case of PP against Darkashi and another. In this case, two accused persons were charged for drug trafficking under Section 39B of the Dangerous Drugs Act 1952. The charge was read before a Sessions Court judge and no plea was taken. The said judge proceeded to extend the remand as the chemist reports were still pending. The accused person followed on to apply to the High Court against the decision of the Sessions Court. They applied to the High Court on whether the Sessions Court had the power to postpone the case and extend the remand. the High Court dismissed the application on the grounds that the subordinate court has the power to postpone the case and remand the accused pending the production of the consent and requisition of the public prosecutor. Another case to illustrate that the consent of the public prosecutor is essential in the transfer of cases is the case of PP against An Ki Cheng and another. In this case, initially, the accused was produced before the magistrate's court. The said court ordered for the case to be transferred to the High Court. An argument was brought up about the consent of the public prosecutor that must be obtained. It was decided that the consent of the public prosecutor is vital and the case can be transferred so long as the accused has not pleaded guilty yet and the evidence has not yet been adduced. To sum up the first issue, as per the illustrated cases earlier, it is clearly proven that the consent of the public prosecutor is vital in the transfer of cases from subordinate courts to superior courts under the Criminal Procedure Code. Failure to gain consent may render the transfer of case to be null and void. That is all from me. I am Surika Varugis. Thank you.
Good day everyone. My name is Ainshafika binti Abdul Rahman with metric number 273206 and I will be discussing the second issue, which is whether the transfer of cases will expose the accused person to a greater punishment. Under the second limb of the provision of Section 177 of the Criminal Procedure Code, it states that when the magistrate feels that the sentence imposed on the accused is insufficient to punish them and that a harsher penalty should be applied, this case may be transferred to another court under this reason. This was also provided under Section 87 subsection 2 of the Subordinate Court Act 1948, where it states that when a magistrate hears a case and that he becomes aware that he might not be able to impose a sentence that goes beyond the 5-year maximum penalty as allowed by the law at the time he was sentencing the accused person, thus, the magistrate has the power to transfer the case to session court. The reason was strengthened in the case of public prosecutor against Tengku Hitam, where in this case, it was agreed that the prosecution must determine whether the highest penalty that a court can impose is appropriate before presenting the case to that court. If it believes that such penalty is insufficient, the case should be presented before the appropriate court that can impose much appropriate punishment to the accused person. For example, a case that may typically be tried in a magistrate court should be brought to session court, and this shall happen only if the prosecution believes that following conviction, the maximum penalty that can be inflicted by a magistrate is insufficient such that it could be brought before a sessions court. The requirements of Section 87 subsection 2 of Subordinate Court 1948 should only be used when the case takes an unexpected turn and the evidence has been introduced showing that the trial magistrate's maximum punishment is insufficient in order to punish the accused person. The issue at hand comes in conflict when there is an argument which states that the Section 177 of the CPC is contrary to Article 8 Clause 1 of the Federal Constitution. This was contended in the case of Raja Petra Kamaruddin against public prosecutor. In this case, it was argued that the Section 177 would expose the accused to the greater punishment powers of the session court, and this is what being in contradiction with Article 8 Clause 1 of the Federal Constitution, as there will be no equal protection of the law as guaranteed by the Constitution to the accused if the accused was to be exposed to such higher punishment than he shall obtain. The court in this case disagreed with the argument and state that the transfer would enable the accused to be tried by a more capable and experienced judge. The court further state that it should not be presumed that the accused will be receiving a harsher sentence from the session court if the accused was proven guilty. Furthermore, if the accused is not pleased with the sessions court ruling, he has 2 more avenues for appeal. Therefore, it can be stated that the transfer of cases did not cause the accused to be exposed to a greater punishment, but it gives opportunity to the accused to be tried with a more mature judge. That's all for my part. Now, I will pass to the next person who will discuss about this.
Hello. My name is Kodis Niraju, metric number 273805. Today, I will be presenting the suggestions for the issues mentioned on the transfer of cases. First of all, consultation with the desired state before forwarding request for transfers of processes and translation of simply a summary of the case at this stage would really help to solve the issue. So now let's talk about the technology here. Technology has become a huge part of our time, and the pandemic has forced its use and integrated it into all relevant fields, including the legal field. Technology can help keep track of cases, including transfers, and make sure they are handled properly. This will make it easier for the cases to be handled, to be moved from the lower courts to higher courts without needing the approval of the public prosecutor. However, each court has its own way of ruling, which leads us to the next discussion. How much compensation a court can give varies from court to court. Both the judicial magistrate and the executive magistrate can drop or bring back cases. An order made under these rules must come with a note explaining why it was made. Until the case has been moved, the court has a good reason to worry that it won't be able to do justice in its own area. So, nextly, best case management system. We have an option to adapt other countries' strategy and system that's used to handle these issues. In that way, better case management system would play a huge role. No matter what kind of communication channel is used, a good case management system is the key to making sure that everything goes smoothly. It helps to connect the organization by giving agents the support they need to act on and solve cases, such as creating the activity history, escalations, and important customer data. In our country, we have a system called e-filing system, electronical filing system, which is a way to gather all the important information about the ongoing cases, the parties, and the law. What we need more of to make things easier is a system that is more well established, well known, and efficient in the same time. This will show us the right way to do things and give us all the answers that are in question.
Now, we have come to the conclusion of this video. With regards to the issues and suggestions explained earlier, it is evident that the law will not allow injustice on the side of the accused, as well as it comprehends substantial procedure when it comes to transfer of cases from subordinate courts to superior courts. The Criminal Procedure Code has laid down important provisions on these matters so that it will allow both parties to have a fair trial. Earlier, we looked into the case of Raja Petra versus Kamaruddin. An interesting point to learn from this case is that transferring cases is important to ensure that the fairness and equality is preserved amongst victims and accused, whereby the judiciary will always remain as a palace of justice. This is one of the many importance as to the transfer of cases in Malaysia. Other than that, the consent of the public prosecutor is significant to ensure the effectiveness of the criminal justice system. This is so because the public prosecutor acts for the society and in the public's interest. Therefore, the public prosecutors carry the utmost responsibility in ensuring that all prosecutorial conducts are not against the law. As mentioned by my learned friend in the context of suggestions, consultation with the state is also a better means as it guarantees a safer and faster procedure. Compensating for damages caused due to unclear intentions of making a transfer, as well as the establishment of the Better Case Management (BCM) system provides for parties to improve in their management and decision-making skills. This helps both parties in making sure that the case is properly managed, and the compensation system ensures an alertness and strict compliance to the law. So now it is clear that the power to transfer cases carries weight to the entirety of a criminal case and should be exercised accordingly throughout the judiciary. So, that is all from my group. I hope you have learned a thing or two. Thank you.